Good morning, good afternoon, and good night for those of you joining us from afar. We are starting our third day of the colloquium on future work for UNCITRAL in the area of dispute resolution. And we are going to look into a proposal that was tabled at the working group and at the Commission on adjudication. And in order to guide us through the discussions and the presentations, I'm giving the floor without further ado to my colleague Judith Knieper, who is well known to all of you because she has been servicing Working Group 2 and Working Group 3 for many years now. And she will lead our discussions. Over to you, Judith.
Thank you very much, Anna. Welcome to this Wednesday morning session of the colloquium. So the topic that is on our agenda today is an outlier in the sense that it's the only topic that does not deal with the topic of dispute resolution in the digital economy. It is indeed, as Anna already mentioned, a topic that was suggested in 2018 when the working group discussed possible future work in the general context of expediting arbitration. At that point in time, the working group decided to recommend to the Commission that work on expedited arbitration procedure should be given priority for future work. And as you all know, because many of you have participated in these discussions, the Commission mandated the working group accordingly to work on such expedited arbitration rules. And last year, the Commission was able to adopt these rules. When adopting the rules at that same session, the proposal to prepare rules on international adjudication was reiterated as a useful complement to the work on expedited arbitration. And consequently, the working group decided that we should hold a colloquium on adjudication, and this is what we are doing today. When we were discussing for the session, we faced some terminology issues, and you will see in the other UN languages that we very often used a long phrase to translate the term of adjudication. And this is because the term of adjudication is used differently in different contexts. So just to clarify at the outset, what we want to discuss today is a mechanism whereby parties can refer a dispute to an independent and impartial party who is required to make a decision in a strictly limited time frame after having heard both sides. This decision is subject to a challenge, either through arbitration or litigation. In other words, the decision of the adjudicator is at first binding but not final, and it attains its finality only if not subsequently challenged. The timeline for challenges elapses or if unsuccessfully challenged. Adjudication has therefore also been described as a form of interim dispute resolution, as a solution to secure a payment expeditiously and argue later. Pay now, argue later. The main idea being to not disrupt or cause additional delays to a given project. We have today 2 hours at our disposal, where we will, like we did for the other sessions of the colloquium this week, first hear presentations. We have 5 eminent speakers, all of which have extensive experience in the area of dispute resolution, and what is more important in the context of today's sessions, all of which have extensive experience in the area of adjudication. For the sake of time, I'm not going to present them to you that would take me already 2 hours just by going through their respective CVs. So you find them on the website, on the webpage that is dedicated to the colloquium. And without further ado, I will give the floor to our long-standing delegate from Switzerland, Michael Schneider, who is the person who is going to introduce us to the Swiss proposal, which you also find in our working paper 225, also on our website dedicated to this colloquium. Michael, the floor is yours.
Thank you, Judith. The way I want to address the subject is before presenting the Swiss proposal, which proposes a particular solution to the application of adjudication in international disputes. I would like to give a background on the importance of adjudication as a new tool for the resolution of complex disputes and as an important message that the practice in those countries where it is applied sends to us setting frameworks for international arbitration. In order to address this last point, I'd like to present shortly the context, in particular in the context of the frequent complaints we hear from the practice of international arbitration that arbitration has become too long and too expensive. And the reasons for these complaints are diverse, but a major reason for this complaint is the growing complexity of disputes, or better, the refinement with which the dispute resolver, those on the side of the parties and those on the side of arbitral tribunals, address the matter. To give you an example of this development, I take a situation from the construction industry. That is, any construction needs a certain sequence. You have to start with the building, you have to start with the foundations, put up the walls and the roof. And this sequence requires some planning. When construction started millenniums ago, the sequence was just followed, and probably without much planning, except that we have from the Roman time Vitruvius, who told us address these matters. But when we had in arbitration construction matters some decennies ago, the planning was simple. We were shown a bar chart with the different activities. And then the sequence of these activities became more problematic. And in the 1950s, the US Navy invented the PERT planning, and Dupont de Nemours invented what has become to be known as the critical path. From then on, the critical path has become a regular feature in construction planning with complex networks and more complication. The matter was put on a computer program. The most best known of these programs is Primavera, and today there is hardly any major construction without such computer programs. And we are here already in the field of digitalization, to which construction has moved with the logic in the construction. And as a parallel to this development in the construction industry, we have in the construction disputes a similar complication, a similar development in the way how these disputes were solved. 60, 70 years ago, the disputes over, let's say, delay were resolved by an intelligent guess of the arbitrator, who then surrounded that by nice words, but there was no Primavera program, no critical path. This has changed, and now there is a vast quantity of evidence. There are experts that are presenting various aspects of the disputes. There are site records, manpower records, equipment records, daily, weekly, monthly reports, and the like. So we have here an example of the flood of information, which was another subject of our discussion in the last 2 days. Now, the point is that this is inherent in the way how the projects developed and inherent in the way how disputes are are conducted in this field. I just give an example. 2 weeks ago, I had an 8-day hearing on a delay issue, and each party had 3 experts, one for technical issues, one for quantification, one for delay. Of course, they were all of different opinions. Then there were experts, there were documents, and that is an example of how construction disputes become complex and costly. There are examples from other industries. In order not to prolong, I just give a short example from the field of long-term supply contracts, gas pricing, price revisions. If you have a reference to the domestic market of the supplier, you have a gas market value analysis where the experts look in all kinds of disputes, including the boilers heating in the households and the variations in their efficiencies, or the number of buses that are using gas in public transport. So these are the, excuse me. These are the elements of complexity that lead us into the costly processes which we face today and which everybody is complaining about. Now, the increasing refinement in the way how the disputes are presented and the tools for planning and implementing these mechanisms are the analysis or are the source of the complications. The rough estimates of earlier days are replaced by a very sophisticated analysis in great detail, and we hope through this greater detail to be closer to reality. But we don't really know, and it is not really clear whether these additional sophistication really brings us much closer to the truth, and if there is a truth in these disputes. So the question is there does the law of diminishing returns apply to the additional practicalities or the additional analysis we are doing increasingly in the arbitration, and which cause the difficulties and the costs in these matters. And that is a general problem, not just in construction arbitration or in gas pricing arbitrations, but it is a problem that in most arbitration cases is an issue, and about which we in the arbitration community and in the organ that looks after these matters, which we should consider very seriously, because the problem we are facing is not just one of what is called the due process paranoia, there is much complaint about, but also excessive sophistication. Now that brings me to the subject of adjudication. In the United Kingdom, the legislator or the construction industry and those who think about it have found a very intelligent solution by adjudication, that is to say, an immediate decision in a month or so, which must be implemented immediately and which can then be followed by an arbitration or a court proceedings. Now, this arbitration is a safety net if the adjudicator gets it wrong. But what is important there is the result of this introduction. The construction disputes, which were a major problem in English courts and English arbitration, have drastically reduced. And the message we get from this situation is that the users are, in most cases, satisfied with the rough and ready solution of the adjudicator and do not wish to continue in costly arbitration. So I think we should seriously think about these possibilities where an adjudicator or a person who looks at it rapidly and provides a solution in a very short period of time is a solution to the much complained about problem of costs in arbitration. And while we have talked much about the question of due process, of fairness, another problem that the industry tells us frequently, they want a solution rapidly, and if it often is enough that it is approximate, provided it is rapid, and the parties concerned can turn the page and move to other subjects. And this, I think, is the important message which I mentioned, that the English experience and the experience of some other countries, we will hear more about that, sends us through the experience of, apologies, sends us through the application of adjudication. Now, that brings me to the specific subject of the solution. Judith has given us an introduction that the subject has been discussed for some time already. And from our perspective, the approaches that can be taken in UNCITRAL are either an addition to the model law, that would be an internal domestic application, as it is in the United Kingdom and some other countries about which we will hear, or have a mechanism in the arbitration rules. And through the Swiss proposal, which I will present now, a solution through the arbitration rules has been developed. You will find the proposal in the Annex 2 Working Paper 225. It has been distributed in advance of the session. It's WP 225, and a explanatory note that provides the background to this proposal. I underline that it is a proposal, the first attempt to deal on the international level, and that's where we see the problem. On the international level, a solution that allows a practical implementation. At present, adjudication is available only in the countries, in a certain number of countries, and in a number of construction contracts, model contracts. FIDIC has provided for it, the World Bank provides in certain contracts. But the problem with the national legislation is that it is not internationally enforceable, and the same applies for contract provisions. And that is a challenge which the Swiss proposal attempts to resolve. And as Judith explained, the mechanism is immediate enforcement, but the possibility of revisiting the decision after the enforcement. So the point is that the adjudicator's decision is at the same time immediately enforceable and not final if a party is not satisfied with the outcome. Now, the first issue, the international application enforcement, the solution we have seen, and the only solution which seems practicable, is the New York Convention. The working group may wish to consider whether there are other possibilities. We heard yesterday on certain platforms that there are automatic enforceability. Whether this is applicable in this context, for the moment we have some doubts, but it may be worth looking into other forms of application. But from at our level, from our examination, it appears to us that we have to find a solution with the New York Convention. Now, the question, the fact that the decision of the adjudicator qualifies as an award, we don't think that is a problem. A point that needs to be considered is whether the possibility of in a new arbitration or in another arbitration, questioning the outcome is something that puts into question the enforceability. At first sight, Article 5 2E 1E doesn't seem to be in conflict with the approach of an enforcement of the adjudicator's decision. In addition, the problem of provisional nature is resolved in the Swiss solution by the fact that there is a limited period within which the adjudicator's decision can be addressed. That is, we suggest 30 days. It can be a different period. I apologize. Different period, but basically after 30 days, the decision becomes final. And then the other point that is problematic, or which in our proposal seems to be the most creative aspect, is that in order for the contesting party to go to arbitration, they must comply with the first decision. And that ensures, in an international context, the immediate compliance. For instance, the adjudicator says a certain amount must be paid. The party that is the losing party on that aspect must make the payment in order for them to reopen the dispute in an arbitration. That is the mechanism that ensures the immediate payment. And what it does, in fact, the first reaction could be that parties say, why should you be obliged to pay if there's no final decision? The matter is that it is not a final payment. It is simply a shift in the cash flow situation. Normally, the respondent can sit on the money and wait the years until the payment, until the arbitration is completed. By this mechanism, the cash flow situation is reversed. It is the claimant that has the money, and the respondent must, if it doesn't accept, must pursue the former claimant in reimbursement. That is, if you look at it from a commercial perspective, not an unfair situation, because either party is in an unfair situation that the other party can hold back the money. So you have there an impartial preliminary decision that the situation should shift, and we consider this is a very fair solution. And again, the very impressive lesson we learn from the English practice is that most parties are satisfied, or perhaps they are not satisfied, but they consider the decision of the adjudicator sufficiently acceptable that they do not go to the cost of the long arbitration. I will not, we have made a proposal for the rules that could be adopted. We have tried to make them as short as possible. We don't need to present them in detail here. I simply say there are two additional protections. One is that the adjudicator may be faced with claims which he or she do not consider ripe or capable of being resolved in the adjudication. Therefore, the adjudicator can say, I will not make a decision on this particular claim or this particular aspect and leave this for the arbitration. The other is that the adjudicator can order a guarantee for the performance in those cases where the claimant appears insolvable or in financial difficulty, that it would be a risk for the respondent to make the payment. In closing, I would say what we have described as an element of adoption described as a procedure in construction contracts is a lesson for arbitration in general, and in particular with the mechanisms we discussed in the last 2 days, where there are decisions, especially in electronic methods with an algorithm or artificial intelligence, parties may be prepared to take the risk of such a procedure, but they may want to have a protection, a safety net, and in such situation also this type of procedure may be useful, and I think we should be grateful to the legislator in the United Kingdom of having presented such a creative solution, which we should take as a lesson for responding to the complaints of many users with respect to costly and long-lasting arbitrations. I thank you very much for your attention.
Thank you very much, Michael, for this broad historical and policy background information, and thank you for referring extensively to the experience of the United Kingdom, because that makes it very easily, from the point of view of the moderator, to introduce my next speaker, who will present exactly that, the experience of the United Kingdom, which has more than 25 years of successful adjudication records. So we will be able to listening to Lindy Patterson, Queen's Counsel, who is a full-time arbitrator, dispute board member and chair, and most importantly, a UK adjudicator. Lindy, the floor is yours. Thank you.
Good afternoon, good morning, good evening to everyone. As Judith has said, adjudication has been with the UK for almost 25 years. It was brought in to deal with what was considered to be difficult payment practices being operated by people in the construction industry, as a result of which contractors had to wait many years for payment. In talking about this today, I will just simply, by way of background, explain as a supplement to what Michael has had to say, that one of the features of construction contracts is that there are regular, either monthly or progress-related payments over a lengthy period of time. And this is important when we look at the application of adjudication. The adjudication provisions came in at the same time as certain restrictions on payment practices were also legislated for to prevent abuse, and that is important, and I will explain why later. But in essence, these payment provisions restricted the rights of an employer, that is the paying party, to withhold payment on an interim basis. So the scheme which was introduced in the UK and has statutory effect is that one can obtain an adjudicator's decision on any dispute, any type of dispute in a contract for construction operations within around 28 days of a formal reference. Parties are able to extend that by agreement in an unlimited way, and I will explain my experience of how that has worked. Unilaterally, the party who takes the dispute to adjudication may extend it to 6 weeks. But as you can see, it's a very short time scale, especially compared to arbitration. The decision of an adjudicator is temporarily binding, or if the receiving party or the paying party does not take the matter to arbitration, it will become final and binding. Enforcement of adjudication decisions has been very successful in the UK. The courts have been hugely supportive of it. One can obtain a summary judgment on the basis of an adjudicator's decision. The courts will not inquire into the merits of the originating dispute. And in general terms, the right to challenge an adjudicator's decision is limited to 2 categories. One is where the adjudicator has acted contrary to the rules of natural justice. It requires to be a reasonably significant breach, because obviously we are talking about a short timescale within which the adjudicator deals with the dispute. So due process is not quite dealt with in the same way as in arbitration. But to take as an example, there was a practice for some time in the UK of particular adjudicators being nominated by claimants who were perhaps perceived to be more favourable to a claimant's case. And that has really been dealt with quite strongly by the courts. So natural justice is still a major part of parties' challenges. And the other one is where the adjudicator exceeds its jurisdiction. So where the terms of reference of the adjudicator have been exceeded. And the reference of the adjudicator is contained within something that we call a notice of adjudication. So if the adjudicator oversteps the mark by making awards that have not been asked for, that will be struck down, sometimes in full, sometimes there will be a severance of part of the adjudicator's decision, which is considered to go beyond the reference. These grounds of challenge have really developed over the last 25 years, and I believe that everyone in the UK who operates in this field knows pretty well the limited circumstances in which an adjudicator's decision will not be enforced by the courts. So we have quite a strong body of case law on that. Michael referred to rough and ready justice, and that is certainly the view that the courts have taken, which is parties have gone to adjudication, they have an opportunity later to challenge it, but in the meantime, the legislation requires, for reasons of cash flow, that an adjudicator's decision will be enforced. What I would say is that it has developed, I think, in a way that was not expected by those who raised or introduced this legislation. And what I plan to do is to identify four aspects that I think may be relevant to consideration by UNCITRAL of introducing this internationally. And the first one is the nature and type of dispute. It was envisaged at the outset that this would be the type of dispute which would be referred to adjudication would be these interim payments that a contractor was entitled to receive either monthly or in accordance with percentage of progress. And the whole thrust of this was that it was important that a contractor was paid as the project proceeded and was not denied funds that might then affect the progress of the project itself. In reality, adjudication now covers all sorts of disputes. And for example, at the end of last year, I did a hugely complex damages claim for claims against an engineer working on a project. It involved a number of technical experts and the insurance company of the engineer was involved, etc. But it was a dispute arising under a construction contract because contracts with what we would call the consultants, the technical people involved in designing the project also come within that definition. So as you might imagine, it is difficult for these disputes to be dealt with within 28 days. And in my experience, generally, these will be dealt with parties' agreement between about 3 to 6 months. And the adjudicator can play quite a strong role and a part in deciding the timescale for that. If as adjudicator you believe that you cannot deal with it within a timescale that parties agree upon, it is up to an adjudicator and they're perfectly able to resign in those circumstances. But in my experience, parties will typically agree upon a timetable that's considered to be acceptable. So that, in effect, I think, turns adjudication almost into a mini arbitration. There will not typically be a hearing in these circumstances, but in these complex claims, I would, for example, have a meeting either in person or online, particularly with the technical experts to discuss the issues and gain a better understanding. And in the one that I'm referring to last year, I had separate meetings on the technical and on the quantum or monetary aspects. So that is a development that I believe those who introduced adjudication did not foresee, but I think it's also a sign of the success of adjudication that parties are prepared to take these disputes to adjudication. One thing I think that is worth considering here is to avoid ambush. And the challenge here, of course, is when there is a short time scale, if there are going to be lots of expert reports issued with the originating document in adjudication, it is unfair. And I would suggest, contrary to natural justice, if that is the first time that the receiving party has seen these and they're only given, for example, 14 days to reply. So as a result of that, we have had some developed judicial reasoning as to when a dispute has crystallized, and parties will require to have exchanged the issues between them prior to initiating adjudication. If it's simply a progress payment which has been unpaid, that is a different issue. But if a party is seeking delay costs or damages for breach of contract, it will be expected that parties will have exchanged particulars of the dispute before the adjudication begins. And I think that is a very important part of it. The next part is the context of counterclaims, because obviously if the receiving party is able to advance extensive counterclaims, it is going to limit the capability of an adjudicator to deal with these issues within the timescales. But having said that, it is also, of course, important that an employer has a right to advance these. So the way that it has operated in the UK is that as part of the same legislation that introduced adjudication, the employer's rights to withhold payment because they had a counterclaim were severely restricted, not in limiting their rights forever, but in the context of cash flow. So if an employer was stating that they were not going to pay a contractor, for example, because of some breaches of contract, in terms of the legislation, the employer is required to issue a particular notice within a timescale, a particular timescale. And if they did not, they would not be entitled to use that as a reason for non-payment. It did not remove the employer's right forever, but it removed it in the context of cash flow and transfer of funds following an adjudication. It has gained a number of complexities, which I won't go into here, but it is an important one, I believe, to consider when considering and introducing adjudication. What is to happen to the employer's counterclaim in that context? So these, I think, are the most important points. As far as extension to other sectors are concerned, I agree entirely that this form of dispute resolution must be capable of being introduced into other sectors, particularly, of course, those that involve long-term contracts where there are regular interim payments. And the two sectors where it's certainly been under discussion, although nothing has ever happened to date, are defence contracts and IT contracts. So that is something for consideration. I think the interesting thing about the construction sector is it is a readily identifiable set of participants in construction contracts, perhaps in a way that other contracts do not lend themselves to, and that may be why it has been easier to apply it to the construction sector. Actually, I would double back and just say one final point that's worth consideration, which is Over 90% of adjudicators' decisions in the UK go no further. In fact, I think currently it's over 95%, which does show that parties are prepared to accept it, as Michael said, as the final decision. And that includes in very complex issues. One thing that is worth thinking about, however, is if it does go to arbitration, in the UK, it is as if the adjudicator's decision did not happen. So it is not a case of challenging the adjudicator's decision. In many ways, the whole dispute is looked at afresh. But of course, the burden of proof question comes in because the party who has paid over the funds initiates the arbitration because they want the money back. But if one treats the adjudicator's decision as never having existed, arguably the burden of proof rests with the party who has received the money. And that is something that the courts have looked at over the last few years also. So there are some considerations as to how one proceeds in arbitration once the money has been paid over, given that it is only, as Michael said, a cash flow situation. It's not an ultimate determination of the dispute. So the party who has received the funds, although they will be the respondent in the arbitration, in effect is the claimant. So that is my presentation. Thank you.
Thank you very much, Lindy. Indeed, that was very instructive, and definitely I have to change my introductory remarks. We are speaking about digitalization because already the second speaker is referring to it. So what we are going to do next is hear two presentations from Canada, one from the common law perspective and one from the civil law perspective. And I would like to give the floor to Pierre Grenier, who is the partner of Dentons in Canada and the president of the Institute of Mediation and Arbitration in Quebec. Pierre, the floor is yours.
Merci.
Thank you, Judith.
Madame la secrétaire.
Distinguished secretary, delegates, participants. I'm pleased to give you the historical background which led the government of Quebec in 2018 to implement a pilot project aimed at facilitating payment to companies which were parties to contracts and subcontracts for public construction projects.
Il m'apparaît également important.
I also think it's important to underscore the results drawn at the end of this pilot project, which concluded in 2021. Quebec is the first provincial jurisdiction in Canada to have such regulation initially under the form of a pilot project. The pilot project contained a mandatory payment timetable and a process aimed at settling in real time, in other words, quickly, disputes which arose during the implementation of work. The process is called adjudication in English, and it is characterized by the issuance of a non-final binding opinion. The construction sector in Quebec has tens of thousands of companies and more than 175,000 workers. In 2013, a group of more than 20 associations of construction companies formed a coalition, and the purpose was to put an end to the unjustifiable increase in payment delays in the construction sector. The coalition called on a major consulting firm to carry out a study, and the conclusions of that study, which were concluded in February 2015, highlighted a number of shortcomings, the following shortcomings, in the traditional contractual management model for construction projects. The delays in payments were due to non-respect for contractual clauses, delays in the approvals of some changes during project implementation, to the cumbersome nature of administrative procedures and to the slow pace of the issuance of payment authorizations by professionals overseeing the work sites. The consequences of these late payments are significant, namely a negative economic impact costing more than $1 billion annually, liquidity problems leading to difficulties in companies paying their employees, their subcontractors, and their suppliers, and interest costs arising, resulting in more than $137 million per year, loss of productivity, and an impact on the competitiveness of the industry. At the same time, the Public Commission investigating the granting and the management of public construction contracts in Quebec issued its report in November 2015. Pierre, I'm sorry, Pierre, I apologize, Pierre.
D'adopter des dispositions.
The members recognize the negative effects resulting from late payments and the issuance of issued recommendations to the government to adopt legislative and regulatory provisions to propose in the contracts. Pierre, we can't hear you very well. Could you please put your headset back on, and could you use your earpiece microphone, because the audio quality does not allow for proper interpretation.
Pierre, je crois qu'on vous a...
Pierre, I think we've lost you.
Yeah. Je pense que je suis...
I think I probably pressed the button. Yes, that's good now. So please speak clearly into the microphone. Thank you. So it is against this backdrop that our National Assembly adopted a law in December 2017 aimed at improving the monitoring of public contracts and authorizing through a ministerial ruling the implementation of pilot projects to explore different measures to facilitate payments in public construction project contracts and subcontracts. Quebec is a civil law province. Our civil code in Quebec has a number of provisions for company contracts and services applying primarily in the construction sector. Despite any inconsistent provision in a general or special law, such as the Civil Code, the legislative measures which were adopted in 2017 grant the power to stipulate conditions and modalities to allow for a timetable for payments and recourse to a dispute settlement mechanism. In July 2018, the Treasury Board issued a ministerial ruling to implement the pilot project to apply to public construction contracts and subcontracts, and the modalities of this ministerial ruling were subsequently reproduced in a rule on the law on contracts for public bodies, public works. And that pilot project ended on the 1st of August 2021. At the end of the pilot project, there were 47 contracts out of 52 which were put out for public tender. Last March, the Secretariat of the Treasury Board issued a report on the implementation of the pilot project. Here are some comments, favorable comments, and some facts which support the maintenance of this approach. The stakeholders benefited from a payment timetable The payment timetable allowed for predictability of payments, and there was better coordination between the public body and the general contractor. The parties were able to resolve their disputes amicably whenever they arose during the implementation of the contract. And there was the possibility to have recourse to a settlement mechanism in real time during implementation of the contract. And the parties appreciated this, particularly because of the quick pace at which that was made available. And the 11 files were the subject of a request for an advisory opinion through an adjudicator. The report of the Treasury Board Secretary confirms that the pilot project was conclusive. The conditions and the modalities proposed in the model pilot project worked well, and although some elements can always be improved upon to make this system work even better, the feasibility and the relevance of having a long-term and comprehensive solution to address late payments have been demonstrated through this pilot project. As a result of these positive results, the National Assembly of Quebec promulgated a law in December of 2021, which provides for the modalities of this pilot project being applied to 180 new public construction projects, as long as these contracts would conclude at the latest in December 2025. So these are the few comments I wish to share with you. Thank you very much for your kind attention, and I will remain available for any question you may have about the pilot project. Thank you.
Pierre, merci beaucoup.
Thank you very much, Pierre, for that introduction to the pilot project aimed at facilitating payment to companies in the context of public construction, and which was implemented, I think it's worthwhile saying, it was implemented at the initiative of the private sector.
I'd like to give the floor to Alan Stitt, who is also a long-standing delegate from Canada and the president and CEO in his life outside UNCITRAL that seems to exist. He's the president and CEO of ADR Chambers. Alan promised to have a provoking presentation, so I'm looking very much forward and give you the floor. Please, Alan.
Thank you very much, Judith. Thank you to everybody. I'm going to take a little bit of a different approach to this. And what I usually try to do when I'm addressing a topic is I first go back to first principles, and I'm going to try to go back to very first principles. And first principles in the sense of, why does UNCITRAL exist? And what is the purpose of this working group? And importantly, what is the purpose of this week? And I think we know that UNCITRAL exists to facilitate international commerce. It's the Commission on International Trade Law. We're trying to help businesses that do work internationally to do it better. And what we're here for this week is not to figure out which topics we find the most interesting, or which topics we like the best, or which topics are popular and are being used by a lot of people. We have a lot of, we've heard a lot of information, and we have a lot of potential good projects to work on, but our task is to select the project where we are most needed and can provide the most value to help facilitate international commerce. And so what I'm going to talk about is why adjudication is so important in terms of facilitating international commerce, and really importantly, why adjudication is in urgent need of guidance. As the members of this working group know, when we created the rules for expedited arbitration, we tried to balance due process and getting a quick result. And we did that with our expedited rules. But what happens when the balance doesn't meet the needs of the parties? So what happens when money is owing from one party to another, and the party will go bankrupt if they don't get paid immediately, and they don't have the time even for an expedited process, or the other side won't agree to an expedited process. And the case isn't sufficiently clear that they can get a summary decision. That if you're wondering whether that is a problem in international commerce, I think the answer is clearly yes. And we certainly have seen evidence in Canada that it is a problem in international commerce. So there's been a groundswell of pressure from the business people to do to help them do their business internationally, to find a way to get a neutral to make a decision on evidence that allows a project to continue, and then allows the parties to deal with the merits of their issue at a later time if they want to. And that, of course, is adjudication. And one model of adjudication was the model talked about by the speaker from the United Kingdom. You heard the model about Quebec. The distinguished delegate of Switzerland has put together an idea for a different model. I'm going to talk a little bit about the model in Ontario. But what's really important, and the main point I want to leave with you, is that the business community is looking to us as the dispute resolution experts at UNCITRAL to help them figure out what the best practices are to deal with adjudication as it grows so rapidly. And there really are no best practices out there, and different countries and different people are doing different things. People want us to come up with a model to help them get out of the abyss that they are currently in. So I will briefly talk about the example I'm most familiar with, and that's the example in Ontario. And the organization in Ontario is the Ontario Dispute Adjudication for Construction Contracts. The acronym is ODAC, ODACC, and you can find information about ODAC if you want at odac.ca. But I'll give you a really brief overview. Our business community in Ontario demanded an adjudication model. They went to the government and they said, this is necessary. We need this, particularly for construction contracts. And I was tasked in my organization, we were selected to come up with an adjudication model that worked. So I looked at the different adjudication models that were being used in different parts of the world, and I saw how different they were. And I tried to take pieces from each of them, the best pieces. I tried to come up with some new pieces and design a model for Ontario. And Ontario has legislation to support adjudication. And some of the key features, just really briefly, are the decision is rendered in 30 days. The claimant gives their material, and then 30 days later, there is a written decision. So it is extremely quick. And one of the unique features of our system is that we have a proportionality part of the system so that the fee will meet the amount in dispute. So for example, for disputes of approximately $30,000 to $40,000 US dollars, there are limits. You can only make 10 pages of submissions. You can give up to 25 pages of documentary evidence plus the contract, and you get half an hour to do a presentation at a cost of $1,000, about $1,000 per party. So it's a very inexpensive process to come up with a very quick decision. And we have actually, for smaller disputes, even a quicker process with fewer documents, and some of them have no oral presentation. We certainly have a process where the adjudicator can decide to have an online hearing or a live hearing. The adjudicator gets to decide on the process after input from the parties. And what's crucial, if you're thinking, well, wait a second, this isn't fair because we don't get due process, the parties always have the ability, if they don't like the decision, to go to arbitration in court, as you've heard. And as you've also heard, parties generally accept the decision. And our experience so far in Ontario in the last 2 years is that we don't know of any examples where the parties have gone to court. They have always accepted all of these decisions at adjudication. What's important, though, is that I'm not trying to convince you that the specific rules we have in Ontario are the best ones. Perhaps the best ones are those proposed by the Swiss delegation, or in Quebec, or in the United Kingdom, or in Malaysia, or in Australia, or elsewhere. But my objective is to try to demonstrate how the business community really needs ways to get a quick decision, often to stay alive, and they need us as UNCITRAL to work on this issue urgently. We in Canada are regularly asked, how do we get adjudication clauses into our international contracts? And the problem is we can't help them right now because there are no internationally accepted rules. Many countries don't have adjudication regimes, and people are left not knowing what to do when they want adjudication. And our concern is that if we put adjudication aside and say we'll deal with it at a later date when things evolve, we won't be fulfilling our mandate to facilitate international commerce. We've heard a lot over the last few days about the digital economy and how ADR is moving online. No doubt it is. I know my company has administered thousands of online mediations and arbitrations over the last couple of years. And the thing is, though, about online dispute resolution, it's huge. It's much bigger than adjudication, but there isn't the urgent need to deal with issues. The things that are happening online, things are happening fairly consistently around the world. And that's not to suggest that this is not a project we should undertake, because I believe we should. I'm saying it may not be quite as urgent. And what I would like to see is that the stock taking that we've talked about in what is going on digital and the digital economy, we need the stock taking, and that we allow time for the stock taking. And in the meantime, we jump in and deal with a project that is in urgent need of some guidance, and that is adjudication. And I'm not confident that I know what the best practices are for adjudication. I don't know the best practices, but I'm extremely confident that the adjudication community and the international business community needs help from this group of experts about what best practices should be, and needs that help as soon as possible. Thank you.
Thank you very much, Alan, for reminding us what we are here for and what we need to do. I hope that everyone can hear properly now, because I'm getting a lot of messages in the chat, and I was told that I should not move, so I try not to move at all. Eiko Kuyama, who is servicing the working group from Vienna, is taking care of all of that, and I'm very grateful she is, because servicing a working group that is not a working group but a colloquium is much more complicated with the 700 people we have online. So thank you very much, Eiko, for taking care of that. We heard now very comprehensive presentations from Canada, and the civil law and the common law jurisdictions seem to both act at the request of businesses who require the need for adjudication. I would now like to give the floor to Jesucito Morales, who is the chairman of the Philippine Institute of Arbitrators, and who is both a lawyer and a civil engineer. And he will give us an insight into the situation in the Philippines. Thank you very much, and Jesucito, the floor is yours.
Thank you, Judith. Distinguished representatives, esteemed secretariat, and the fantastic organizers, good morning, good afternoon, and good evening. Thank you for giving me this opportunity to be part of your work in dispute settlement. Next slide, please. Allow me to present how we from the Philippines view the UNCITRAL Working Group 2 document number 225 on adjudication. And in the process, I will be sharing our national experience, policy, and economic background in the hope of finding a way forward on work on adjudication. We share that adjudication would be an efficient means to solve disputes in long-term contracts and a means to ensure provisional enforcement of decision. Next slide. The view that is thus advanced is, unlike an arbitrator who is chosen to exercise a judicial function and to resolve a dispute based upon submissions by the parties. An adjudicator, on the other hand, is chosen for its expertise in a certain subject matter and often does its own investigation or appreciation of the issues with or without submissions by the parties. Next slide. In point are two things. As Ms. Lindy mentioned earlier, she also has two things, natural justice and not exceeding jurisdiction of the adjudicator per the notice or submission. So I will also focus on two things. In point are the taking of evidence and appreciation of the issues. Next slide. On taking of evidence, it is given that the adjudication process must complete faster than expedited arbitration would. I think all the speakers are unanimous on this basic premise that the adjudication process must be completed faster. Otherwise, what's the use? However, unless the adjudicator is empowered to make its own investigation, that is dispensing with having to strictly comply with procedural due process requirements that are a feature of arbitration or litigation, it would be virtually impossible to take evidence in the quality desired of an expert on the subject within the contemplated shortest time frame. Now, I would like to expound. We have to recognize that, as described earlier by Michael, the highly technical nature of the construction projects. And while I understand in the UK model, on the UK system, they are following the case law. And then the element or the requirement of natural justice must be present. The trade-off will have to come in. As mentioned by, I think by Alan, what is the need of the business community? So, as an engineer myself, we don't look at case law when resolving construction disputes, the highly technical ones. Because in science, in mathematics, in engineering calculus, these are demonstrable, derivable. So case law would not have much beachhead head or use or functionality. It is more of the engineering calculus. That is why if you would have looked at the statistics, there is like a 90% satisfaction or acceptance. So let me repeat that it would be virtually impossible. So here lie the trade-off. To take evidence in the quality desired, because if an adjudicator is constrained with having to follow each and every procedural due process requirement, his hands would be tied. And in the quality of an expert, and even if the adjudicator, for instance, is an expert, if he does not have a free hand to appreciate the scientific nuances, it would be impossible for him to come up with a quality determination within the contemplated shortest time frame. So the first premise is it must be able to be achieved within the shortest time frame. The question, therefore, is it doable with the natural justice or procedural due process constraints? Next slide, please. And then on the appreciation of issues, I understand the UK model would be strict on the adjudicator exceeding its jurisdiction as defined or as described in the notice of adjudication. Appreciation of the issues, adjudication has been used in either single or multiple issues. for a single issue, we have in our minds as a picture the progress payments as mentioned earlier, I think by Lindy, as is typical in a Security Payment Act. Of course, a Security Payment Act is familiar to us, to everyone. It is seen as a mechanism to provisionally enforce cash flow. In finance, for instance, the investors are not looking at, or the funders are not looking at the health or lack of it of the balance sheet. They are looking at the net present value, the cash flow. So as mentioned by Alan earlier, what are the needs of the business community? Are they looking at the balance sheet or at the net present value, the cash flow? So it is a mechanism to provisionally enforce cash flow. That is, progress payments do not get withheld, so that work under long-term contracts get to continue. I think this is the most important of all, and not disrupted by a dispute, as such is thereby adjudicated away in real time. Next slide, please. I think you have to go back one slide. Okay, on the multiple issues, deeper appreciation of which is already aided by having an adjudicator who is an expert. The element of having an expert for an adjudicator is compelling, especially if you are looking at the very complex, highly technical projects. As an engineer, I have seen really fantastic engineering mathematics. He has to be an expert on the subject matter, but confidence on the same is further built by having one constituted at the start of the execution of a project. We call it in FIDIC the standing dispute board. It is constituted at the start of the execution of a project or implementation of a contract, and not ad hoc, or not only when a dispute has arisen, so that it would not only have been made familiar with the issues as they develop, but would have anticipated them as well from its vantage appreciation of the risks and responsibilities allocated to the parties from its observation early on of the contract configuration. By contract configuration, an example of this is the allocation of the risk and responsibilities differ if the contract configuration is, for instance, build only. It is different if the contract is design build, or if the contract is engineering, procurement, and construction. It is different if the tenor is fit for purpose from specifications performance. So he must be an expert, and he must have observed the developing of the risk as the project goes on, and the nature of the project. Is the project electromechanical, or is it simply civil structure or structural? Is it fit for purpose or performing to specification? Being executed or contract being implemented. Next slide, please. The Philippine experience, and this is the economic background in our region, on constituting an adjudicator is one of hesitation, if not reluctance, even if such is called for in the contract. This is because of what is perceived is a perception in our place to be a regrettable upfront expense that is to be made over a provisional only disposition in a way of a matter in dispute. To overcome this, a budgetary amount for it should have been mandated or agreed, and thus allowed or provided for as part of the project cost, like a pay item in the bill of quantities, so that forking out for it should not deter or hinder adjudication moving forward. In our advocacy in the Philippines, I had the chance of interviewing so many contractors. I asked them, you have a dispute adjudication board in your contract. Why are you not constituting the adjudicator? And they said, it's because we don't know who will foot the bill. And it is not part of the budget. It is not a pay item in the bill of quantities. So that is a problem in our culture or in our region. But this might be a solution to that. Next slide, please. Advocate about the economic benefits of adjudication in long-term contracts much outweigh the upfront cost, therefore. As mentioned by Alan earlier, do we have the pulse of the business community, what they need? Are the funders looking at the balance sheet, or are they looking at the net present value? One report has it that the cost of adjudication would be about 0.2% only of the project cost, while results of one survey suggests that use of adjudication to resolve disputes achieved a 4% savings in project cost and a 16% saving in time. If anyhow, these figures could be true, and probably the statistics would be able to help us. Using adjudication to resolve disputes would be 20 times economically advantageous than not. So basically, the decision makers would be the investors, the funders. Are they looking at the balance sheet or at the cash flow or the net present value? Next slide, please. The Philippines itself, though, does not yet have statistics on adjudicators' decision being referred to or escalated to arbitration or being upheld or overturned, noting that, as mentioned earlier, the Philippine experience on constituting an adjudicator has yet been one of hesitation, if not reluctance, even if such is called for in the contract. And may I hasten to add that as we speak, currently the Philippine Department of Transportation is seeking the constitution of dispute boards for about 20 of its current infrastructure projects, and each one of these projects would cost more than 1 billion pesos. And then model clauses on the same should be promoted for use in contracts. Next slide, please. An independent agency may by law be empowered to act as the appointing authority. Currently in the Philippines, we have the Construction Industry Arbitration Commission, and basically the recommendations is to expand its charter to act as a default appointing authority. In default of the parties' agreement designating another. If the parties' contract would have designated another appointing authority, good, well and good. But if not, there has to be an appointing authority that is empowered or conferred or vested with some jurisdiction or allocated with some jurisdiction, with powers to accredit adjudicators and to promulgate standards and practice rules, etc. Finally, an international convention like the New York Convention or a model law like the UNCITRAL Model Law on International Commercial Arbitration may be had for the cross-recognition and enforcement among adherent countries, not only of an adjudicator's determination of a dispute, but also its award of legal, if there is no contractual stipulation on an interest, on the amount being provisionally enforced by way of liquidated damages. So in our experience in the Philippines is that the UNCITRAL Model Law and the New York Convention of 1958 have been really very helpful and is being upheld and followed, and it's really doing good in the business community. I think that's my last slide, Nicola. So thank you and good afternoon.
Thank you very much for this very comprehensive presentation and for also pointing us to the questions that we should discuss now. We heard a lot. We heard that there are issues regarding the scope, so construction or beyond for all long-term contracts. We heard some remarks regarding enforceability. We heard some experiences from the context of domestic adjudication, and we are here discussing the context of international cross-border trade law. We heard some practical issues that might come up, especially in the very last presentation by Jesucito. We heard some suggestions of what we could potentially work on, starting from contractual rules to arbitration, adjudication rules, to model law, to a convention. So everything is on the table. And I would like now to open the floor to the participants to give us your point of view, to see what would be your evaluation, whether we should embark in such work. As this session is meant to be informative, I would also like those who have further information to be provided, further experience that they might have had with adjudication, to put that in front of us. And with that, I would like to open the floor. And I see that India is requesting, yes.
I would like to thank the Secretariat for the excellent arrangements met for the ongoing session of the UNCITRAL Working Group 2 on dispute settlement. This session, with various presentations and views expressed, provides an excellent opportunity to understand the fast evolving issues relating to the online dispute resolution. I thought I'll just touch on the issue of adjudication, because I think that's dear to us. For us, as we may agree, adjudication is the most important aspect of any dispute resolution process. What we have today is the diverse mechanism of adjudication based on various legal systems and procedural aspects that are followed. We have faced this in commercial disputes, in investment disputes, and other disputes as well. As a common law jurisdiction, many a times we are faced with aspects of other legal systems as the other party hails from a different legal system. So it is important to have a balanced set of adjudicators who understand the legal systems that would be part of the subject at the dispute. Unfortunately, what we come across is a clear divide between legal systems, and this is not limited to arbitration but goes beyond to the court proceedings that arise out of arbitration. It is therefore important to try and work out a common set of procedures and model laws to try and minimize the issues and to try harmonize the legal systems as best as possible. This, we believe, can be achieved by having experts from across legal systems sit together and first figuring out the differences and then trying to bridge them. Thank you very much.
Thank you very much indeed. I have on my list reserved 46. I'm not quite sure what that means or what that stands for. It's the US. Luckily, I recognize, no, it's
Singapore.
Singapore.
Thank you, Judith. First of all, our thanks to the Secretariat for the work on this, and to the presenters for sharing their experience on adjudication. We are open to exploring adjudication and its international application, although we point out that in our experience so far, its application has been domestic. We would like to share that Singapore currently has an adjudication framework under our local Building and Construction Industry Security of Payment Act, and this has been in operation since 2005. And it is separate and independent of arbitration proceedings. And major standard construction contracts in Singapore do generally provide for arbitration as a means of resolving disputes between the contractual parties. And adjudication under our Security of Payment Act is an option that is over and above the contractual provisions. If the working group takes on adjudication as a topic of study, we anticipate that there will also be issues of harmonization and cross-border enforceability associated with an international adjudication framework that would need to be addressed. Generally, Singapore's Security of Payment Act legislation, it applies to all contracts where parties carry out work or supply goods or services in the construction industry for projects in Singapore, and any contract provision that attempts to contract out of the Act is void. The adjudicator's decision, which is known as a determination, is binding, and the adjudicated amount must be paid within 7 days after the adjudication is served. And determinations can be enforced under the court process. They are used as an interim measure to resolve disputes. That is, parties are bound by the decision until and unless the decision is reversed or modified by a decision of a court or final determination of an arbitrator. A determination under our Security of Payment Act legislation is typically reached within 2 to 3 weeks from the appointment of the adjudicator. And the process is quick and economical so that a construction project is not stymied by protracted proceedings. In Singapore's experience, after adjudication, many parties do not pursue the dispute further. And as the distinguished delegate from Switzerland alluded to in his introduction to the proposal earlier, there are 2 reasons for this. Firstly, parties may consider the amount awarded in the adjudication is considered acceptable, with any difference no longer worth pursuing because of the costs of litigation or arbitration. And secondly, the differences between the parties have been narrowed by the adjudication determination, and parties were able to reach a settlement on the remaining issues. The legal standard for proving a claim in an adjudication is currently just for the claimant to show a prima facie case that they are entitled to the claimed amount. The adjudication framework is theoretically capable of applying to other types of commercial disputes as well. It is essentially an expedited interim measure for parties to resolve their dispute subject to any litigation or arbitration between the parties. So in our view, a harmonized legal framework is good to have. We are open to further discussions on this. The Swiss proposal alludes to one possible way to ensure international enforcement of an adjudicated decision. Although I would again point out the practice of adjudication based on our experience so far has been domestic, and we are interested to hear from delegations as to its international application. Thank you.
Thank you very much, and thank you very much for providing additional information and pointing us to this question of internationality. I have 2 more speakers. I'm not quite sure in this Zoom, it doesn't indicate who was first, so I do think that Israel had the hand up first, so I would give the hand to Israel, and with apologies if this is not in the correct order. Roni, you have the floor.
Thank you, Judith. I would first like to thank the distinguished delegate of Switzerland as well as the speakers for this thorough and educating presentation. While we recognize the many benefits of the adjudication, especially in its expedited manner, the benefits do seem clearer in some sectors better than others. Accordingly, it is not sure that the aim of the project should be to modify the UNCITRAL arbitration rules, especially since the expedited arbitration rules were recently approved. It could be better to see how the expedited arbitration rules are used before any further amendments to the UNCITRAL arbitration rules are introduced. Additionally, it seems that adjudication is better regulated through domestic legislations and contracts between parties. As this mechanism is not familiar in several jurisdictions, it could be problematic to introduce it as an international instrument. At this stage, it seems to us that consultations should be made with experts to examine whether or not there is a need for UNCITRAL model or a convention or an amendment to the UNCITRAL arbitration rules. So perhaps this project could endeavor to establish guidance instead of normative standards. And so Israel would agree to the Secretariat following this topic and further developments. Thank you.
Thank you very much. I have next on my list Finland. Finland, please.
Thank you. Do you hear me?
We hear you very clearly.
But you probably do you see me? Okay. Well, I will first thank the Secretariat for these documents, for this preparatory work which has been done for this meeting. This has been they are very valuable, and also the speakers here, in particular Mr. Schneider, who has made this initiative, has been a very good initiative, and I think that adjudication is really a project that we should take on our program rather soon. I mean, immediately, I was quite impressed by the intervention of Alan Stitt from Canada. I think he just expressed my thoughts better than I could have done myself. But I think that this is the way we should go. What form should this work be take? I think, of course, a convention might be too ambitious, but I'm open for a model law provisions, rules, or whatever. I think this is something that remains to be discussed. But I think even though in my country, I don't, to my knowledge, adjudication is not very much practiced, but I know that among the bar lawyers and also people in particular in the construction industry, think there is a need for that. And if there is no framework, it doesn't work. And also in international matters. So I think this is something that we should take very seriously, this suggestion. And I hope that there are very good grounds to put it on the program for UNCITRAL. In what form, and that remains to be discussed. Thank you very much.
Thank you very much, Finland, and I have next the Netherlands in the room.
Yes. Thank you, Madam Secretary. Thanks to the Secretariat for the outstanding preparation and the documentation and the information also from the speakers. Most interesting. I would like to use the invitation in the beginning of this session made by Judith, saying, well, it's also interesting to hear from other countries what they offer as a concept comparable to what has been what is on the table now, and what we have and what is very successful in the Netherlands, that is what we call curiously binding advice, bindend advies, a binding advice. Why advice? Because it doesn't lead to an award or a state court decision. It is a private adjudication leading to a decision which is considered to be binding in that sense that if a party, the losing party, doesn't enforce it, then you have to go to the state court or arbitral tribunal and claim for performance of it. So the construction is that the binding advice becomes a part of the contract, sale contract, sale leaseback, doesn't matter. So very general approach. It is successful not only in B2C cases, but also in B2B cases. Why? Because you will not get an award, you will not get an enforceable decision. I think that is probably because it is less stringent. It is more familiar. It is more sympathetic may be in commercial relations and relations between business and consumers. That is what we have, and maybe it is comparable to, and till a certain extent, I have to be very careful, certainly in this room, to a certain extent with the Italian arbitrato irrituale, and with the Belgium bindende derdenbeslissing, I translate it literally as binding decision by a third party, and with the German Schiedsgutachten. And of course, there's no time to go into details now, it's not important. There is a certain similarity. What I want to say at this very moment is that these examples show that it is important when we proceed this way and choose this subject to make very clear what exactly we mean, what exactly we want to rule. Because there are a lot of types of adjudication apart from state court jurisdiction and arbitration, adjudication in a very broad sense, which can draw our attention, but I think it would be good to focus on a specific type of adjudication. Thank you.
Thank you very much. Next, I have France in the room.
Merci.
Thank you very much. I would like to, first of all, thank the Secretariat and Switzerland for having put forward such an interesting topic for our consideration. I have a little bit of knowledge of this kind of adjudication, in practice even of it, and from what I know, it presents a huge advantage. In the sense that it functions, it resolves issues, and it does so quickly. As far as I know, having said that, this is fairly widespread in the area of construction, in the dispute boards, that is, and there is a FIDIC regulation has already, to a certain extent, regulated this phenomenon. But the question that I've asked myself fairly frequently is this: to what extent can this be generalized? We talked about long-term contracts here. And what I'm asking myself sometimes is that the reason it works is because there aren't always legal specialists involved, and the adjudicators are very frequently engineers. And it was said frequently that the engineers, even if they are appointed even by representative of the parties, do not have in the spirit legal considerations. They have a specific problem in front of them that they need to resolve. And when you have engineers, they find solutions to a problem they're faced with. And if this is something that we need to bear in mind. One thing is clear here is that this is a solution that already exists to a certain extent, and it's effective. It has been proven to be effective, and as such, and therefore warrants UNCITRAL's consideration. Without necessarily speaking overwhelmingly in favor of it, nonetheless, it warrants being considered. There's an issue here which is linked to the execution or even to the implementation, to the progress of a project. And it's because it's not always cash flow problems, and they can be resolved differently through various kinds of guarantees. But there are also, even with that, the execution of that is an issue. If we continue discussing this, we should be thinking about other issues that come in here. The authority of the awards. The awards, for example, the decision made by the adjudicator, if it goes on to further litigation on similar issues, could have an impact on a future adjudicator or in arbitration proceedings. And lastly, from experience, I could glean that the committees of adjudicators could sometimes become a problem for parties because parties have decided to negotiate so that as to resolve a difficulty. And then that they see that the decision time is coming and they see that they cannot resolve an issue, they launch an adjudication process knowing that this will not give them a resolution, but they do it so as to be able to go on to arbitration. So I was an adjudicator at one point, and I was forced to go through a simile of a procedure, pro forma procedure the parties were not interested in. They simply wanted this to be able to move on to arbitration. So we have this mechanism which works very well in many a situation, but sometimes it can become a pro forma procedure from parties. But this is very rare from what my experience tells me. But to conclude, this is an interesting topic that warrants being considered. Thank you.
Very much. I have next the PCA.
Thank you very much for giving me the floor. I hope I can be heard well. This is an answer to the invitation to provide information regarding the use of adjudication in different contexts. For our part, we have reviewed cases in the PCA's practice as appointing authority that involved a two-step dispute resolution process comprised of first adjudication and then arbitration. And in a nutshell, our review supports the notion that there are issues to be addressed, as well as the potential usefulness of a proposal such as the one put forward by the distinguished delegate for Switzerland. All of the cases we reviewed had been escalated to arbitration and were addressed to the PCA for the designation of an appointing authority or for the appointment of an arbitrator. The dispute resolution mechanism in each case was contractual, so my comments today are limited to contract-based adjudication, excluding statutory adjudication. And I should mention that these comments relate exclusively to cross-border disputes, as these arose in different parts of the world, or rather I should say cross-border disputes between parties from different jurisdictions, and that also relate to very many different parts of the world. Probably there are cases among the ones we reviewed from each continent. Nearly all of the cases were in the construction sector, with the exception of just a few that arose in the telecommunication sector. And although this last part is a very small sample, it's notable that while in the construction sector, and this was just mentioned by the distinguished delegate of France, there's a certain uniformity among adjudication arbitration clauses, partly due to the use of FIDIC form contracts. The provisions in the telecommunications contracts did provide for adjudication, but their drafting was more ad hoc, and they contained instances of problematic drafting that could have benefited from the use of model clauses or the incorporation of procedural rules. Across these cases, there were two main reasons for escalation to arbitration. The first was that the decision of the adjudicator had not been complied with by the party that had been ordered to make a payment. In these cases, arbitration was used essentially as the only available path forward toward an enforceable decision. And this observation supports the notion that additional incentives could be put in place for voluntary compliance with adjudication decisions. It's notable, in fact, that where an adjudication had taken place, in all cases but one, the claimant in the adjudication was also the claimant in the arbitration. So this was a party which had already received a decision in its favor and now had to go to a second step in order to get an enforceable decision. The second reason that we observed for recourse to arbitration is that in many cases, no adjudicative body had been put in place. In some cases, this was because one party had failed to nominate an adjudicators. In others, it was because the parties could not agree on one or more adjudicators or on an appointing authority. In yet other cases, and this was mentioned by Mr. Morales, it was because the parties had deemed it economically inexpedient to constitute a disputes board early on in the relationship, before any dispute had arisen. And so whatever the reason, these cases show that provisions such as the ones contained, for example, in the Swiss proposal, where in paragraph 3 it includes a simple and, shall I say, for UNCITRAL, a classical UNCITRAL solution for the appointment of adjudicators after a dispute has arisen. This addresses another issue that quite frequently seems to arise in practice and seems to be a cause for the adjudication process, so to speak, to fail and require escalation to arbitration. So, as I said, the practice that we observed supports the usefulness of a proposal such as the one put forward by the distinguished delegates for Switzerland. That said, with regard to the need for a provisional enforcement mechanism, it may be interesting to further investigate whether non-compliance with the decision of an adjudicator happens mainly when the relationship between the parties has broken down and the contract has perhaps been terminated. We've seen many examples of that, or whether this problem also arises with a certain amount of frequency during ongoing projects, which is where adjudication is said to be most needed as a rapid provisional method for resolving disagreements. Thank you very much for taking the time to listen to me.
Thank you very much indeed. I do have 8 more speakers on my list, so I would ask you to be quite concise and short so that we are able to take everyone. The next one in line is Argentina. You have the floor.
Good morning, good afternoon, good evening to distinguished delegates. I wanted to refer to working document 225. We see that a expedited arbitration, depending on jurisdictions and on the documents and the presentations that we've heard this morning, it's interpreted differently. Some states have already drafted laws on these types of procedures limited to the construction sector. And on the contrary, others are not considering it, and that's the case in my country. We've noted that these divergence in the way this matter is addressed comes from the lack of a legal framework for implementing the decisions of the arbitrators, and also the challenges faced when making an harmonized legal framework applicable. Without prejudice to that, we understand that it would be viable to consider establishing a harmonized legal framework for this issue. And this could then apply beyond the construction sector. That work is something that we could consider. Thank you.
Thank you very much, and thank you very much for being concise. Next in line is the United States.
Thank you to the Secretariat and for organizing this session, and to the many speakers who contributed. We thought this was extremely informative and very useful. Going into the discussion, perhaps the 2 questions that we had were, would this type of approach be useful in other industries beyond the construction industry? And secondly, were there sufficient familiarity across different legal systems that might also lead to the opportunity for harmonization. I think what we heard from these presentations was that the answer to both of those questions is yes. And so we think that this is something that can very usefully be explored as a way to further facilitate arbitration or dispute resolution as a way to make arbitration more efficient. I think we also saw that there may be an element of the cross-border aspect that would be important to consider, and so we are still thinking about what might be the right approach. It does seem like some model clauses could be useful, but I think we are still considering that, and we'll look forward to it. But think that the discussion here has highlighted the benefits of pursuing this type of approach. Thank you.
Thank you very much. I have China next.
Thank you, Judith. We know that adjudication as a dispute resolution mechanism certainly has values and advantages. And in China, we have some experience in that connection, although not very much practice. We will continue our discussion on adjudication. In the meantime, we also need to further study the difference between adjudication and existing resolution mechanisms such as mediation and issues such as the validity of adjudication decisions and the legal basis and the rules and legal basis for the enforcement of adjudication decisions. I think we can start sharing some cases and legislative experience. In the meantime, we can also explore the formulation of practical guidelines and other documents so as to guide those resolution institutions and parties. In this way, we can advance the development of adjudication practice. Thank you.
Thank you very much. I have Spain.
Thank you. Very briefly, I would like to thank the Swiss delegation for their proposal, and we agree with other delegations that this is an interesting issue and should be addressed by our group. We should limit the focus and the approach that we're taking when addressing it. Thank you.
Thank you very much. And next in line is the Russian Federation.
Good afternoon, colleagues. We would like to thank the Secretariat and all of those who took the floor before for a very useful discussion. We also would like to, whilst we're discussing this document, we would like to say that we think it's important to consider discussing adjudication as a means of an alternative dispute resolution and also harmonizing our legislation in this area. Also, overall, we would like to speak in support of those who took the floor before me when they said that, of course, it is important to consider the possibility of continuing discussing digital dispute resolutions, but it would also be desirable to have in parallel work on adjudication. At the same time, we would like to agree with those who took the floor before me when they said that when it comes to the format of a potential document on adjudication, the group could discuss this at a future date within the framework of the working group to discussion. There could be guiding principles or summary practices or some other format for such a document. And as we continue working on such kind of a document, we'd also like to note that when we're talking about an adjudication, what needs to be taken into account is the economic balance of participants. For example, those who order something and the contractors, if we're talking about construction disputes. I thank you.
Thank you very much. And I have Australia in the room.
Thank you, Chair, and thank you to the Secretariat for preparing such a informative background paper, and we thank the Swiss delegation for their introduction of the topic. I just wanted to briefly raise an issue that we've encountered in Australia around our security payment legislation, which adopts adjudication as the method for resolving disputes, primarily in the construction industry relating to payments. And that is that because Australia, whilst Australia is blessed with many things, we have the curse of being a federation, and consequently, this has led to states introducing various different forms of the security payments legislation, which has been around in Australia since 1999. There are two models of adjudication which now exist across Australia under the security payments legislation, and one being the East Coast model, the other one being the West Coast model. And whilst similar protections exist across the various schemes in each state and territory, differences in operation, processes and timeframe requirements cause unnecessary complexity and confusion for parties. And here's the rub. Attempts to harmonise those differences have not been successful to date, and again, and part of the reason for that has been because of the competing East Coast and West Coast models of the Security Payments Act. And so I just really wanted to raise for the consideration of the working group that harmonisation, whilst ideal, may prove to be a little bit too elusive in the international context. And we just raise this as something to be considered in deciding to move forward with this project. Thank you.
Thank you very much. I have Mexico in the room.
Muchas gracias.
Thank you very much. We are grateful that you've provided this space so that we could discuss the issue of adjudication, of arbitration. I think it could be a very valuable contribution by UNCITRAL for agile, effective, and safe, legally safe international trade. My delegation believes that the Swiss proposal is a good starting point for discussing various alternatives. And the last point I would make is that undoubtedly one of the challenges we face is not just thinking about the proper wording so that adjudication works correctly and effectively, but how can we do this and determine whether or not it's viable to have some kind of harmonized scheme? That's one of the challenges UNCITRAL faces. We don't work in a vacuum. Thank you.
Thank you very much. And I was told that it is time to close. I'm very sorry for the 3 speakers that I still have on the list. You will have a last chance on Friday when the topic is again on the...
This afternoon.
We will have this afternoon, so even better.
No, but very short this afternoon.
But very short. You saw the signals from the secretary. Very short means very concise and very short. So with that, I wish you a very nice lunch and see you after the break. Thank you very much.